Thank you, Mr. Chairman. We have heard some extraordinary claims this morning. I've been taking notes as my colleagues have commented on all of this. Congresswoman Sheila Jackson Lee said the executive branch is, quote, taking a wrecking ball to the Constitution. And, Mr. Chairman, you said that the DOJ doesn't recognize Congress as a co-equal branch of government or acknowledge our oversight responsibility. Mr. Cohen said we're trampling upon Article 1. Anyone who looks at these facts objectively knows the truth is exactly the opposite. The Attorney General and the DOJ are objecting to this charade based upon the rule of law. They are trying to protect the integrity of our institutions. And, Mr. Chairman, you said that the preliminary protective assertion of executive privilege this morning was a last-minute outburst. It's exactly the opposite of that. In fact, the letter that the DOJ sent to you this morning says, and I quote, "Regrettably, you, Mr. Chairman, have made this assertion necessary by your insistence upon scheduling a premature contempt vote." The letter goes on to say, "You've terminated our ongoing negotiations and abandoned the accommodation process. And as we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law, court rules, and court orders, and without threatening the independence of the Department of Justice's prosecutorial functions." That's a quoting from the letter. The facts matter. The letter that the Attorney General sent to the President this morning that accompanies all this says, quote, "The committee demands all of the special counsel's investigative files, which consist of," everybody listen, consist of millions of pages of classified and unclassified documents bearing upon more than 24 criminal cases and investigations, many of which are ongoing. These materials include law enforcement information, information about sensitive intelligence sources and methods, and grand jury information that the Department is prohibited from disclosing by law. That's the letter the Attorney General sent to the President explaining all this. Look, we're attorneys on here. Most of us are attorneys on this committee. What does the law say? The courts have repeatedly affirmed the rules on all this. April 5th, just last month, the U.S. Court of Appeals for the D.C. Circuit ruled in McKeever versus Barr. The district courts may disclose grand jury materials only where they have positive authority to do so, particularly through the exceptions to grand jury secrecy listed in Rule 6E. The Court of Appeals explained the vital interests, they said, that the rule of grand jury secrecy seeks to protect, including preserving the willingness and candor of witnesses called before the grand jury, not alerting the target of an investigation who might otherwise flee or interfere with the grand jury, and preserving the rights of a suspect who might later be exonerated. These are critically important principles and traditions for us to uphold, and it is, again, the law. The chairman can file suit for access to the 6E material, but instead he blasts the Attorney General for not joining him in doing so. Why hasn't the chairman taken that step? I think I know why. Perhaps because he knows that his rationale for demanding the unredacted report is wholly insufficient. Look, this bears repeating. The chairman claims he needs the full unredacted report as part of the March 4th, 2019 investigation into the 81 individuals and organizations related in some way to President Trump. But let's make a couple of facts clear. The investigation, we don't even know if it's still ongoing. We haven't heard much about it lately. The lack of activity surrounding the investigations makes clear the majority here is not interested in pursuing this for any legitimate legislative purpose. This is about scoring political points. The chairman's public comments surrounding his need for the full report are almost exclusively focused on obstruction, but another important fact here, 99.9% of the obstruction volume is available right now for the chairman to view, but he hasn't done that. Only 6 lines and over 182 pages is redacted in the obstruction volume. This is not about seeking the truth, as we've heard this morning. It's about raw partisan politics. Our Democrat colleagues have weaponized our critical oversight responsibilities. And moving today to hold the AG in contempt is not only premature, unprecedented, and unwarranted, frankly, it is shameful. I think, we believe, the American people deserve better. I hope that they'll review the facts. I hope they'll look at all this correspondence. I hope they'll get beyond all this cloud of partisan politics and understand why we are taking the stand today that we are. I yield back.